Mr. Inselbuck, I'm an attorney as well, and I'm overall troubled by your general assertion that getting to the truth and doing what's right is too burdensome and too expensive. I understand the need for getting the settlement money to the victims in as reasonably prompt fashion as possible, but the trusts also have a fiduciary duty, do they not, to as yet undiscovered victims to not pay out fraudulent claims?
Absolutely, and they do a pretty good job of that. I observe how those trusts operate. Indeed, the trusts have paid less than 50% of the claims that have been filed with them up to now. This is not a revolving door for claimants. I have seen how these trusts have done audits, how they've uncovered discrepancies, far more interesting discrepancies than the Wall Street Journal found, how they investigated those, how they audited the law firms that were involved in those discrepancies. And I don't see any need for a filing place or for this Congress to interfere in what is a working system that is working very efficiently and very inexpensively, as opposed to the tort system.
Having filed this bill, I'm going to disagree that it's working. One of the things we look at consistently is making information available. And again, I'm a strong believer in the truth will set you free. And I was concerned, and I guess Mr. Scarcella addressed the fact that how burdensome it would be to create these reports. I can't believe, certainly on an ongoing basis, you just, I assume these things are filed electronically. You just have the lawyers requesting the claim put in the summary of the case, and you review it. To me, it seems like it could all be done, and Mr. Scarcella, I guess, agrees with me. This is all just a data function that is, for the most part, already in place and wouldn't be that burden. I just want to make sure the record's clear on that. Is that not correct, Mr. Scarcella?
Yes, I think the important distinction here is to understand that the picture that's being painted by Mr. Inselbuck is this idea that attorneys for the trust, paralegals, and claim reviewers are going to have to sit in rooms with stacks of documents redacting information before it's turned over, and that's why it will take so long to produce this.
They're not the federal government. They actually have computers at work.
Yeah, it is not that way. The professionals he speaks about that he's met with recently at the claims processing facilities, I used to work with these people as an outside consultant, and I used to have to analyze their data for doing future claim projections, which is one of the backbones of bankruptcy trust and how they distribute their money both currently and in the future. And in my experience, whenever I needed to request data, far more extensive data than what the FACT Act is proposing here, I was able to get it in virtually no time at all. It took no time, maybe a day lag for them to produce to me a data set far more robust than what the FACT Act is seeking here, so I can do my analysis to try and help the trust figure out how they should pay claims in the future.
All right, we could probably spend the rest of the afternoon going into the details of this, but I do want to talk about the bill in particular. I want to ask Judge Abelman, as we've produced this bill, do you think it strikes a fair balance between addressing the needs of those who suffer from asbestos-related diseases now and need to get their claims paid promptly, and the need for protecting those in the future?
I absolutely do think that it does. I don't see how you can argue against openness and transparency, because that just makes the judicial process what it's supposed to be, which is a fair process where both sides are playing on a level playing field. And I think the bill protects the rights of the victims who have succumbed to this dreadful disease, but I also think that it probably provides more protection in terms of confidentiality of their records than the legal system is able to do.
Great. And I want to ask Professor Brown, again, just kind of setting up the record for this. Could you expand on your testimony that the FACT Act is an appropriate exercise of congressional authority, given that the Section 524G trusts are authorized by the Bankruptcy Code, but authorized under state law?
Of course. Yeah, I find it kind of interesting that that's even a question. When I was in the course of my research last year, one of the lead firms in New York came in and argued that the state court shouldn't be demanding this information and discovery and otherwise because it was a violation of the sovereignty, the supremacy clause. But when we look at it from just a matter of the bankruptcy power, any conception of the bankruptcy power, even the narrowest conception, is a restructuring of the debtor's affairs with its creditors. And any act related to that falls under the bankruptcy clause. I don't think that's even seriously in question here.
All right, we just wanted to make sure we got that on the record. Thank you, Professor Brown. Thank you to the rest of our panel. And we'll now go to the gentleman from Georgia, Mr. Johnson, for 5 minutes.